Sure. Shall we start?
Yeah. Good evening, everyone. My name is Amin Johar. I am a senior resident fellow and I lead the Center for Applied Law and Technology Research at Vidhi. I'm joined by my colleague and co-author for the paper that we'll be discussing today and the moderator for today's session, Dhruv Samyajula. And we're also joined by Ms. Srinidhi Srinivasan and Mr. David Joshi. So I just wanted to set the context briefly for what we are doing. Basically, Vidhi had come out with a reference in December on the recommendations of the Joint Parliamentary Committee that has now been tabled in the Lok Sabha and the Rajya Sabha. That report is yet to be adopted, but it makes some interesting observations and comments and inputs on the current draft of the PDP bill. And the likelihood is that going forward in this year, at some point, that bill will be retabled, possibly with a few modifications and subsequently passed. So we are now looking at these through several working papers that will be coming out on a monthly basis. We will be looking at certain aspects of the PDP that have either evolved through the conversation over the last 2-3 years, or are either underlooked or need to be highlighted again now that this conversation is resurging. With that, I'll hand it over to the moderator for the day. Dhruv, please take it forward. Thank you.
Hi. Thank you, Amin. Thank you, everybody, for joining the call. I'd like to first introduce the panelists in today's discussion. We have, as Amin mentioned, we have Srinidhi Srinivasan and David Joshi with us. Srinidhi is a principal associate at Ikigai Law. She has extensively worked on India's proposed data protection laws and has helped examine how these provisions would interact with the business ecosystem and how it would be impacted by these provisions. Divij is a lawyer and researcher who's been working in the tech policy space for a while. He has experience in terms of working with autonomous decision-making systems in being used by the government in India, and he's currently working on the law, regulation, and politics of platform infrastructure as well. So I welcome both the panelists to this discussion. Before we get going, I'd just like to give a short summary of the paper that we're discussing. The paper discusses the right to informational privacy and its facets, which include the right to control how one's data is used or shared. It then looks at the traditional notice and consent framework, which takes consent at the point of collection. And we see how that could be insufficient in protecting autonomy and consequentially informational privacy. The ubiquity of personal data processing through AI or IoT systems and a general lack of awareness regarding the extent of this processing raise concerns that we feel would be better addressed by a system where control over one's personal data is a continuing exercise that goes beyond the point of consent. From that lens, the paper reviews the rights, obligations, and enforcement measures being set out in the PDP Bill 2019 in terms of how much control they allow a data subject to have over their data. We also discuss aspects of the powers of government agencies to be given exemptions from various provisions of this bill in light of how the government has been introducing AI projects and IoT projects in recent years. While this paper does cover all of these points, they also raise a lot of interesting areas of discussion. And that's why we are here with these eminently qualified panelists who will, I'm sure, provide us great insights on these issues. To briefly set out the flow of the event for the attendees, we shall be first taking a few opening views from the panelists, and we shall follow it up with a wider discussion on the theme of today's panel. If time permits, towards the end, we shall be taking a few questions from the audience as well. I think we can now start with the opening remarks. Srinidhi, would you like to go first?
Great. Hi. Thanks so much, Dhruv, Amin, and the Vidhi team for having us here. It's lovely to be here. I'm Srinidhi Srinivasan. Like Dhruv said, I'm a principal associate at Ikigai Law. I lead our data practice. We're a law firm with a sharp focus on tech and innovation, and we often work with startups and others in emerging tech sectors like AI, where AI-driven solutions in healthcare in particular, in the microcredit lending space, financial sector, and blockchain, other emerging tech areas as well. I think I'll start with perhaps stating the obvious, which is that there's been an explosion of new applications, products, technologies that rely fairly heavily on data in the over the past few years. A lot of these applications have sort of this public good or public service element as well. We've been doing a fair bit of work, for instance, in the AI in healthcare space. So using AI in improving patient outcomes, healthcare delivery, better diagnosis, minimizing scope of human error. In the IoT space as well, I think some use cases around, say, something like use of IoT for better hospital administration and other similar themes in the financial sector, for better underwriting, bringing more borrowers into the fold through non-traditional sources of credit as well, working towards financial inclusion. I think, like with any other piece of tech or new development, raises the need to discuss some different themes and issues, including privacy, responsible use of AI, ethical concerns, issues around bias. And thanks for sharing the paper, Dhruv and Amin. I think raises some interesting points there. And I think I'll just maybe set out three perspectives that I had, and we can delve deeper into those during the course of the session. One, just to begin with, I think this notion that emerging tech sort of exacerbates privacy concerns. I know that's a theme that's reflected in your paper as well, and I think no doubt some of these technologies do pose certain kinds of unique concerns. I'll take the example of blockchain tech, though I know that wasn't the focus of your paper, but I thought that was an interesting use case here. So any data that's stored on a blockchain can't be erased, and because of the immutable nature of blockchain, which may be at odds with something like a right to be forgotten, which is understood as important to empower individuals in how they collect, in how their data is disseminated. Examples also, in the healthcare system, of say something like an AI powered chatbot that allows users to that makes interventions, say, regarding their mental health based on what they're saying, directs them to relevant resources, screens for keywords like trigger words for self harm. And there may be questions here around, does the user really know what their data is being used for? Do they have the option to be making different choices? Is there enough transparency and accountability? To my mind, several of these concerns can be addressed by sort of developers having this kind of privacy by design sort of mindset. And while use cases and applications have really exploded, the law hasn't evolved as such. Our data protection law continues to be in the works now for nearly 5 years. And until such time, a lot of the privacy choices that developers have made have been voluntary or to build trust, or in B2B use cases triggered by making the product usable to their customers who may otherwise be in regulated spaces. So I think a lot of the baseline principles in a data protection law, like your transparency, accountability, privacy by design, could help bring that privacy mindset. And having said that, though, I don't believe that we need to micro legislate for emerging tech. I do think that a law that is principle based could help achieve outcomes here. Often we are balancing different rights, the right of an individual to get easier or smoother healthcare while maintaining privacy. And I think a lot of the focus, what would be necessary is to build out sort of a robust regulator that can understand these technologies, work closely with tech experts, cross pollinate to understand the design of products, and have this sort of right balance. Again, I guess examples could be like with AI solutions, the data fed into AI networks is often de-identified. Perhaps Divij can speak to this a lot more, but just developing achievable anonymization standards through a robust regulator, both sort of on the technical side and on the legal side. Similarly, with blockchain, I mentioned this example often because we work a lot with sort of blockchain crypto technologies, and the French DPA, for instance, came out with a guidance on marrying blockchain and privacy, suggestions on how this right to erasure can actually be achieved. So more practical solutions there. could sort of help move the needle. And I think just another thought here. I think not everything is necessarily a privacy or a data protection concern. A lot of the issues that often crop up around, say, ethical or responsible use of AI, possibility of bias creeping in, possibility of discrimination on religious grounds, who has the liability in case of poor decisions. I don't think all of these are necessarily privacy or data protection concerns. There's been a tendency of late to think of this data protection law as a panacea for all ills: non-personal data, fairness of algorithms, hardware, software, security, certifications. But I do wonder if we're trying to do too much with one law, and would be sort of better place to keep the focus at building those baselines, which could be applicable to different use cases and different scenarios as it evolves. I'll pause here. Happy to go into any of these in more detail.
Sure, that sounds great. Srinidhi, I think you've raised a lot of wonderfully interesting points. I think we definitely touch on these again in the conversation. Divij, could we like have a few of your opening views at this point as well?
Sure. And thanks so much. It was a really interesting paper to read. I think what's particularly concerning and emerging technologies captures a lot, but I think what's particularly concerning in the current paradigm of technological development for me is the increasing datafication of people and environments. And what I mean by this is increasing habits of kind of reducing social reality into data points. The ways in which those data is collected, which I guess is one of the, so IoT, for example, is one of the concerns it raises, the fact that there's always kind of ambient and environmental sensing of people and environments going on all the time. And with AI, which is not really a phrasing I like to use because it's incredibly vague, right? But particularly with machine learning technologies and new profiling technologies, I think the concern is then it shifts to how that data that's being collected on various fronts is then being processed and what kind of implications it has. How are people being profiled? What kind of decisions are being made about individuals, about groups through the use of that data? And there's a particular kind of also like scientific method or practices of science that are applied to data science projects, which is also concerning. And that's concerning about what are the kind of assumptions that go into thinking about data as an abstraction of social reality, right? When those assumptions don't play out in real life, but decisions are made on their basis, what does it mean for our own ideas of kind of, one of the ideas you mentioned is privacy as autonomy, which is a major thing, but also other aspects of our social behavior and our social relations, including non-discrimination, including equality and other forms of constitutional rights and values that we hold. And I think that's where I also see the role of data protection shaping up here explicitly, also, obviously, because it is a data governance regime. And I think it's also where we need to start thinking about the limitations of existing concepts of data protection. And so I think what I also want to start off is two somewhat theoretical perspectives on these new emerging datafication technologies and what their regulatory implications might be. And I'm drawing from two works here. One is a paper by Sollenberg and yourself called Big Data's End Run on Anonymity and Consent, which I think your paper also addresses to an extent, and Srinidhi spoke about the limitations already of anonymization techniques. But what it basically argues is that with these new big data technologies and with artificial, machine learning technologies particularly, these notions on which data protection law is founded, which is for one consent and on the other, the idea that you can be de-identified in a context where data collection and processing practices may not harm you anymore or may not affect you anymore, don't hold out so much in the face of these new technologies, which are based on group profiling. And they're based on the the creation of categories that are at a supra individual level or at a population level, which means that when you're talking about anonymization, of course re-identification is a big problem, but anonymization or depersonalizing personal data does not necessarily affect the fact that data processing activities can still affect you at a group level. right? Consider a kind of policy that's being made, say, about sequestered housing or about job applications, which is not based on the fact that you have an individual who is targeted on the basis of the information collected about them, but is targeted on the basis of the kind of group that they might belong to. And that group-based categorization is consistently being created by these new emerging big data analytical profiling technologies. And I think the second problem, of course, then arises with the idea of consent and its own limitations. Of course, I think it's important to keep building on substantive notions of what continuing consent means. But at some level, what this paper also addresses the fact that consent in some cases also becomes meaningless when, for example, somebody else's data is being collected and used to make inferences about me because we belong to the same category or group which this technology has placed it under. It is not something that I can substantively consent to in any way, right? There are very few meaningful ways in which, because it's not my data, it's not my personal information that's actually being processed or used. It's simply a categorization that is being imposed on me. And data protection law currently doesn't address that at all. So we need to start thinking, I guess, a little more substantively about how we address these population level, community level, group level concerns about contemporary data processing activities. And there's a number of ways, I guess we can, we can talk about what this implies for regulation later. I think the second kind of again, a theoretical perspective is also based on what changes machine learning particularly brings to notions of individual autonomy. And this is based on work done by Mirai Hildebrandt and this paper called Privacy as Protection from the Incomputable Self, which basically says that the argument that's made is that machine learning technologies, by doing this kind of grouping and classification and profiling of individuals and profiling and I suppose drawing inferences from historical behavior is that other category of technology, which I think is particularly concerning. It reduces your own individual autonomy to behave and, to constitute yourself in the world in a way in which you want to freely, right? With your own autonomy, because machine learning is necessarily classifying and predicting your future actions in a way and then altering environment so that you are necessarily supposed to behave in that way, right? And that limits the kinds of freedoms that you have, that limits the kinds of choices that you have in various environments, especially if you look at, and we've already seen this, emotional categorization technologies that we use online, which then serve as ads and serve as content and media based on what they think we want to see. So content moderation on online spaces is a very clear example of how, a lot of personal autonomy is limited by the fact that you are categorized and personalized based on certain kinds of inferences drawn about you, which you have very little control over ultimately. So I think these two theoretical perspectives around why current data protection regimes are potentially inadequate, how emerging technologies, go about affecting our data in particular ways is something to keep in mind. And I think that the roots of addressing this in a more holistic way also lie within our constitutional ideas of what privacy is, right? The idea of informational self-determination, the idea of decisional autonomy are built into the Puttaswamy judgment for one, but also, I think more holistically grounded in constitutional values. And I think that's where potentially we can start having conversations about how we want to build data protection regulation based on this.
Sure.
Thank you.
I think these are wonderful points, Divij. I think we'll just get into one of the points that you had mentioned, which was also something that Srinidhi had mentioned. The idea of ethical bias through AI systems, etc., and how we can, while Srinidhi had pointed out that there are other issues with emerging technology other than privacy, etc. It does emanate from data collection and the way past historical data, for example, is used, or aggregated data is used for machine learning to develop these sort of biases over time. So in that context, I'd like to ask a question, and maybe Divij, maybe you can start by your views on this question. What do you think personal data processing or the personal data protection is an adequate way to regulate this umbrella of harms that we might see? Or like as Srinidhi pointed out, there would be other concerns for which there might be any other sort of regulatory framework? Or do you think data processing is where we can start effectively regulating these issues?
So that's a very interesting question, particularly because I think with data and as a kind of, see, it is what we make of it through governance regimes, ultimately, right? Data is a flow. And as a flow, it's constituted not only by kind of what the technology is happening, but how we decide to govern it, how we decide to constitute it, how we decide to, make of it through different regimes. So with a lot of these technologies that are coming up, some scholars have also kind of deconstructed this notion of personal data itself, right? The idea that there is no such real thing as kind of, especially with like the identification technology. And there's a great article that's almost a decade old now by Paul Ohm called The Problem with Anonymization, which basically says that with these new technologies, the idea of personal and non-personal data, these boundaries are very, very difficult to draw, and in some cases don't really make sense. But because we decide to constitute a particular kind of data economy, because we want to build regulation and think of data in a particular way, that's why we've gone the PDP route. There are two ways out of this. Either we can, or two ways to kind of start addressing and emerging this problem now that we've realized that there is more to data than meets the eye, or that meets the PDP Bill's definitions of personal data. There are ways to expand notions of substantive data rights within our framework of data governance that's already, well, it's not in place yet, but potentially in place, that focuses on the individual and provides greater kind of structural protection against the kinds of harms that we're talking about, including fairness, including equality, including expanding on the notion of individual autonomy. And then addressing other harms by, say, having an AI-specific regulation, which addresses the ways in which these technologies are built, addresses hardware standardizations as the PDP bill tries to do, and addresses like algorithmic fairness and so on. Or there's ways of, for example, if you're concerned particularly about the effect on individuals within contemporary data governance practices, you can find ways to allow individuals to have greater control over these systems. And I think like consent is not a great way of doing that, whether continuing or whether one time. Consent has its, I think it's beneficial in some cases, but as a structural problem to the kinds of issues that are raised by emerging technologies, which are incredibly, they're far too complex for individuals to meaningfully consent to any of that processing that happens, or even understand what's happening, right? And simply kind of basing data regime on this very, this notion of the liberal individual subject who is able to understand and take actions based on their rational choice is no longer something that's viable in this digital economy, in the ways in which these technologies are processing information. So there need to be maybe new ways of thinking about within personal data protection. How can individuals receive clearer explanations of processing that are happening?
Yeah.
How can individuals receive, say, profile transparency, which is something that the PDP bill actually does do when it includes inferences within the notion of personal data. It's actually a big step forward in terms of thinking about how these data processing technologies are controlled, because a lot of what's happening in profiling based data processing is inferential understanding, or like kind of, making inferences from directly perceived data that different data processors and controllers are doing. So, there are different ways of going about it. I guess it ultimately depends on how you think about like data as an object of governance itself. I don't think any place in the world really is thinking about moving away from personal data protection entirely, but there can be new ways of, new institutional forms or forums in which we can start to think about systematically addressing harm instead of, again, just like making the individual this like sole focal point of notice and consent.
Yeah, that makes sense. Shriti, do you want to jump in on this question as well?
Sure. Yeah. I think I kind of like Dhruv's framing. Divij's framing on like different regimes make choices, like governance frameworks make choices as to how we view data, how we choose to regulate it, and there is no one way or one approach to look at it. It's perhaps also a function of where we are in the current tech ecosystem, legal policy ecosystem, and the realities of the day. Perhaps even just other government bodies also in parallel working on AI governance, and if it does look like that is a more sort of approachable or more functional, workable solution, perhaps that's the way to go. I think also a function of, to my mind, deployment of AI solutions does go slightly beyond this notion of how informational autonomy or how an individual controls information about them. Depends very much also on the context in which it's being deployed. For instance, if there is use of AI in public service delivery, much greater risk of discrimination goes back to right to equality, more than even any other privacy right or anything else. So I think very much kind of it's a choice that a governance regime makes, and to my mind it goes a little bit beyond just I completely appreciate that this concern has kind of come in because of there is the potential to process large volumes of data, and with IoT devices and AI. I think just the mass use of data, both at the community level and at the individual level. I am cognizant of that, but I do wonder if it goes way beyond just the how do you control information about yourself.
Understood. So, Srinidhi, like I think you'd mentioned earlier that you had worked on the use of AI in healthcare and how IoT devices are used in the healthcare like framing, and AI is being used in hospitals, etc. So, given the sort of like light touch approach that's been followed in the PDP bill and the JPC report regarding emerging technologies, like they've tried not to regulate it like right now very much. So I think, like, is there a fundamental question here? Should emerging tech applications be regulated through a legal framework right now, or do you envision that there is a better way to sort of approach this?
Sure. So I think, like I said in my opening remarks as well, I don't believe we can micro legislate for emerging tech. I'm not sure we're at a point where we need specific laws or regulations for each type of emerging tech application or use case. That is not going to work at all. The law becomes outdated pretty soon. Tech will always outpace law, and which is why I guess privacy and other governance regimes around the world also go with a more principle-based approach and focus energies on developing a regulatory system or an ecosystem where there's maybe downstream guidance around how to regulate, how to govern different use cases that come up. I think great examples would be the UK ICO or the French CNIL, which routinely come up with these guidances around different use cases or different functions on how you regulate. I also do think it's important to have somewhat of an interdisciplinary approach here. And by that, I mean, I did see some references in your paper to say something like dark patterns. And I've heard someone say this, I couldn't recall who and where, that there's just a difference between persuasion and coercion. In a traditional business setting, you're like persuading a consumer to buy a product is good marketing, and employee would be rewarded for it. But coercive techniques are what we're really trying to guard against. But on a UI, this question of what is persuasion, or on a user interface, what is persuasion versus what is coercion, is really not a bright line test. like different colors, is that enough of a nudge? If you get calls multiple times in a day, does that trip into coercion status? Are lawyers or even product developers even the right people to sit and decide this? Who decides for one individual what is persuasion, coercion? So often I think just a lot more conversation around having more people, psychologists, people who have a better understanding of human behavior perhaps to come in, because each of these use cases are also very context specific. And yeah, I think some sort of baseline principle based approach with a regulator that works with different kinds of experts might help the cause.
Yeah. So I think this ties up with the point that you mentioned earlier regarding the importance of privacy by design, by implementing these data protection ideas in the build-up of the system itself, as opposed to a top-down sort of model. So like maybe I think I refer to the AI Act, which is being proposed by like in the EU right now. When I say if we are today not like, is it a stage that we are today not a state where we can regulate emerging tech, or do you think such kind of legislation which is aimed at a particular emerging tech, like how EU's artificial intelligence act is aimed at AI use, etc., do you think we should, like, we can ever get to a stage where we aim legislations at certain technologies, or should we still prefer a more broad principle based uh, like framework? Because the question then arises, where, what are those principles based on, and how are those frameworks then made? Like either of you can jump in on this. Like Srinidhi, like if you don't mind, I think can go with you again for this.
Sure. I think no, yeah, I think fair point. But I think we're still at a stage where we've not really tested out how those baseline principles in even a personal data protection law will play out in the Indian context. With sort of, once we have somewhat of an ecosystem which is where kind of privacy is hard coded into products, or where developers make conscious choices based on privacy because it is mandated by law, privacy by design approach. I'm not sure, I'm not entirely convinced we're at a stage yet where we start regulating for different use cases. Again, I think important to look at the context. I would say if it is AI or any specific deployment by a public sector entity, going too far ahead without any guiding norms, because the risk of discrimination and violation of fundamental rights is extreme. And perhaps that's a framing to keep in mind as well, versus a sort of, the whole startup community or developers of AI who are using it in very different contexts. So yeah, I think context matters here.
Yeah. So Divij, what are your views on this?
Yeah, I mean, I think it's a difficult question to kind of just say when is a technology, or like what emerging technology should you be regulating or focusing on. And I guess that ultimately it's about what is the perceived and actual social impact and its divergence from the norms that you want that interaction between technology and society to follow. In the case of, say, the EU and AI, I would argue even in India for sure, it is a time when we do need to, sorry about that. It is a time when we need to start thinking about these questions, because these are technologies that are pervasive, especially on online media, and are increasingly becoming environmental as well, right? So there are sensors and widespread scalable use of these technologies. And I think that each of these kind of, like, both the development of the technology as well as the methods used to, and I focus mostly on data governance, because I think a lot of these technologies center around the notion of a data economy, are particularly concerning and should be addressed as soon as possible. And there's different ways of assessing at how and whether to step in and regulate in a way that doesn't curtail particular ideas of innovation. One of these is to think about risk and think about impact assessment, right? And the EU, in fact, has very specific ways in which there are regulatory impact assessments are conducted, which talk about like what will be the effect of this regulation on an emerging technology on a particular field. that we're trying to regulate. But also technological impact assessments are something that are increasingly becoming more apparent to when we start incorporating, when we start thinking about technologies and their social effects. What is likely to happen? What are the risks that are likely to be posed to particular kinds of rights, to particular kinds of norms, to specific groups or to specific individuals? How can we foresee them and then act on the basis of those presumptions? So that's one kind of risk-based regulation making is something that has, in terms of emerging technologies, has always been a way in which regulation responds. The other is to look at where is the kind of the notion of risk not sufficient, right? What are the technologies where we think that kind of we want to use uncertainty based regulatory principles where we cannot potentially foresee all the risk and calculate it and respond appropriately, but we think that there is enough of a risk that's potential that's in the future that we want to kind of still have structural protections and be very careful about how these things evolve, right? Nuclear technology is one such thing where we kind of are not always able to foresee very clearly the risk, but we use uncertainty based principles. Environmental law is one where environmental regulation is and its relationship to technologies is one where uncertainty comes up a lot because we know that these are social effects that cannot easily be taken back. So I guess like ultimately it depends on,
Yes.
what kind of choices we want to be making in terms of how we see the social effects of technology panning out in the future.
Yeah.
And of course it will have impact on its development. If we take uncertainty based approaches, it will impact a particular notion of how the technology evolves and innovates and what kind of market-based activities are allowed. If we take a strictly risk-based approach, it means that, as in the EU AI Act, for example, high-risk things are totally banned. Other things are allowed with certain implicit structural protections. Other things are allowed with no. You don't need to do anything in response to them. So yeah, I guess that's kind of
just a
yeah.
short follow-up on this. So when you say uncertainty-based regulation, could this also be viewed as principle-based regulation, as in we aren't sure of, we aren't going to cover every possible risk out there because we can't foresee all of them, but we can at least start proactively listing some principles and then base regulations that broadly don't contradict those principles. Does that seem like a fair characterization?
Yeah, I guess, I mean, you can even have principle-based regulation, which is risk appropriate, but uncertainty-based is more like, the precautionary principle in environmental law, which is that where you don't think you can foresee all of the risks, then the ways in which you go on developing and regulating that system is with regard to precaution about its potential social consequences first, rather than saying that we have calculated the monetary risk of this or we've calculated the social risk. And there are thresholds where like everything above this risk is allowed and anything below this risk is not allowed. Yeah.
Understood. So I think when we speak about impact assessments that are required to be done, or when we speak about privacy by design or any of these other topics that have come up in this conversation, we are looking at how the private sector can participate in the regulatory framework, however that may look. So to that extent, Srinidhi, I think, would you like to share your views on how the private sector and specifically India's startup ecosystem, which is being encouraged very much by tech, and they are the ones who constantly keep voicing their concerns regarding compliance burdens of data protection regulation. So how could the private sector fit in, like in terms of realistic data protection regulation without them suffering onerous compliance burdens?
Sure. Yeah. I think one is just being involved in some of these like policy conversations and debates. That's just a starting point. I mean, just in terms of what might be the requirements that either affect them disproportionately or just if there is like lack of clarity in a proposal or a law. I think often what we've seen with several of say your AI or ML solutions providers is, if especially those that market to customers in Europe and the US, often a lot of the requirements also trickle down, and more than I think the law, it's also this idea of building trust in the product itself, especially in contexts like health or even the financial sector. We see some of these choices being made somewhat voluntarily on how do you just keeping in mind like user privacy or user interest, to be able to sell that product, like which requires trust in some sense. In I'd say, when there is a regulation or a regulator set up, even in the run up to the law, just like the data protection law also suggests this idea of codes of practice, and that industry could come together and have a code of practice, which is then approved by the regulator, and that becomes the norm for that sector. So if there is a way to explore how these codes could develop with a lot of sort of mingling or rather dissemination of ideas, and I guess working with regulators to also understand how the tech works, like what are the different environments in which they operate, and just what are the different choices that they're often encountering, whether they, I mean, also I guess the idea of how a checkbox or just adding, I mean, I know consent might not be the be all end all, but just in terms of if you add a checkbox, these are the massive implications on a business when leading to consumer drop-offs, while also not meeting privacy goals. So I guess some sort of evidence-based, some studies, something that could be a little more bottom up. And we've seen examples of different regulators around the world working closely with the industry in developing some of these standards, be it for anonymization or for just how the law interacts with them. In the IoT context, it could also be just working with the regulator in helping them understand what the system looks like. In a lot of sort of IoT context, it's not very clear who the data controller might be as well. There are multiple nodes, multiple points with connected devices. So just, I mean, I guess also important to have these conversations on how a proposed law might also interact with them. And yeah, I think bottom up sort of codes of practice or standards.
Yeah, I think it would be like a good point that I see a few countries do is when they proactively help the private sector figure out what exactly is the compliance going to involve, right? Because do you think that there is a situation right now where the private sector isn't exactly sure how much or like what is the compliance they're looking at? There are a lot of concepts being thrown at them, a lot of rights of users like data portability, like erasure, correction, etc. And they may have no mechanisms or like frameworks like which they would implement for these when these rights kick in all of a sudden. So how do you think we should approach that mismatch between concepts that the law is bringing in and how ready private sector needs to be for that?
Sure. No, so just last week we done a discussion with startups, and it did speak a lot to just lack of clarity on what a lot of the law actually requires them to do. I would say even something as simple sounding as consent. I mean, it's not simple actually. Consent versus explicit consent. What does that really mean on a user interface? Does it mean that you have either you have the same standard across the board for all types of any just a checkbox, or with explicit consent, does it mean you need to display some more information? I don't believe that the law can granularly set this out because it won't be able to account for all the different products, apps, everything. But I think just helping a lot of businesses understand that the expectation is so and so. Eventual goal is this, that user privacy, you account for user interests at each stage and you're able to sort of demonstrate that. I think the law also gives a lot of occasion for, like, there could be several technical violations of the law, but that might not be the intent of the law. Something, for example, on children's data, on use of children's data, there is a bar on profiling, tracking, behavioral advertising, and any other activity that causes significant harm. So a lot of startups and sort of edtech platforms have this question around, if we're designing a quiz and allowing people to move to the next stage, is that profiling which is not allowed? But surely that can't be the objective of the law. So I think also allowing for some kind of risk-based approach where the principles are sort of set out in the law, and then there is guidance that you work towards.
Yeah, I think we might also see some of these issues coming up when we. Hi, Divij. So I think I was coming to you for this. We might also see some of these issues coming up in the deployment of AI, and because I mean, right now there is a lot of movement in the AI like ecosystem in India, and a lot of it is based on vast amount like machine learning, neural networks, and a lot of it is based on data processing, data learning, reinforcement techniques, etc. How do you think, do you think that at this stage, should there be a regulatory uh, framework that sets it out for the ecosystem, or do you think the law should take its cue on what the ecosystem can first throw up?
See, I think we've already kind of seen, and we are seeing the consequences of data processing activities in new and novel ways using both technology and different kinds of data science methods. I have tried to document these in the public sector context quite fastidiously, and I've seen that they're having very real consequences on people's lives and their rights and their entitlements. Which is why I don't think that this is something for the future. It's not something where we're trying to protect.
Sorry, Divij, I think we may have lost you. I think we just give him a minute.
Hello.
Hello. Hi, Divij. So, yeah, you're back.
I'm so sorry. I'm
Yeah,
not
no
sure
worries.
what's happening, but
I think we'd
yeah.
we'd lost you when you were talking about you had documented these instances in the public thing, and it's not for the future right now. So we were there.
Right. So, and I think that these are consequences that are happening today, and I don't think that it's not a like a burden on innovation for that innovation to be responsive to change, to the needs of society. That certain kinds of data processing activities are inherently harmful and should not occur. That the fact that you're using, say, you're using information processing to discriminate between communities that are based on protected constitutional grounds like caste or gender or race, is not something that we should necessarily be debating. That you're using proxy methods to do it, or that you're doing it in the private sector, for example, through credit scoring mechanisms and using, so for example, what is one major kind of burgeoning innovative technology? It's fintech, right? Fintech uses a lot of data processing activities to characterize and profile people. That profiling is not always something that's a social good. I mean, like, if somebody believes that credit should be, at least something that's universally accessible on an equitable basis, then you probably don't want somebody's historical characteristics of caste or other mechanisms to play into how the private sector lends you money. That's not an innovative practice that we should be protecting at all, but it's something that the PDP bill does in fact protect in the name of an innovation. So yeah, I mean, in that way, I think it's not, I guess, like, the idea is to think about what kind of innovation do we want to foster, and then that's what the law ends up doing. If we don't think that the technology has any social consequences, and we are comfortable making that assessment, then sure, we can go ahead and exempt and say that let this area develop a little further. But I would say that in terms of thinking about data processing that is happening to machine learning techniques and is being applied to populations, to individuals, That's not something, I mean, we're past that stage now. These are technologies that are that are causing harm. And I think it is high time to, if not create new regulatory structures, think about how existing regulatory structures actually apply to them.
Yeah. So I think if I understand it correctly, we are talking about how if we can identify things that we consider are harms, and we can all agree on certain principles on which AI systems or emerging technology systems generally should be developed, we shouldn't then let innovation be a argument that can sort of excuse every way, like every kind of harm that can be generated in all sorts of AI or emerging tech applications. So maybe the PDP bill like introduces structures like sandboxing, etc., which try to uh, give a trial sort of demo sort of a room for uh, innovative emerging tech applications to develop. So do you think these are these are steps in the right direction? Or do you think we should probably tweak the structure of a regulatory sandbox to better suit principle-based development of emerging tech?
I think again, with regulatory sandboxing, it really depends on how it's structured and what kind of rights and protections are already inherent in it, right? It's not a license for you to experiment on populations and do what you want with kind of the state giving you a thappa and saying that you can go ahead and do this because you're in a sandbox. I think sandbox is the entire idea is the idea that harm is limited and addressable, right?
Yes.
That it's a safe space to play.
Yeah.
And it needs to not only be safe for the tech company that's providing services, but it needs to be safe for the environment. And it needs to kind of, any kind of consequences that come out of it need to be able to be addressed proactively um, by the person who is in charge of, right? The teacher who is looking at the sandbox and you playing in it. So yeah, I mean, it shouldn't be like a social license to, or a governmental license to experiment in new ways that can cause irreparable injury, but simply a way in which governments themselves have the opportunity to kind of observe and address potential implications of emerging technologies and then apply those lessons. Kind of, it's a way in which you can have more empirical evidence about emerging technologies.
Makes sense. Srinidhi, from the perspective of businesses and startups, would innovations like sandboxing also be one of those practices that you talked about, that we bring in these businesses and the startups at the ground level, and we involve them in the broader regulation framing exercise? Would sandboxing be an example of that?
I didn't necessarily think of it that way, but I mean,
Okay.
I do agree with Divij that sandbox is more like beta testing a product. It's not like a blanket approval. It can form the basis for the regulator to also understand the tech and be able to then draft regulations around it. And if there is some overwhelming public interest in a product, or if it is completely, say, very narrow use case, or if it's simply not possible to technically implement something like a right to erasure, maybe there are those narrow exemptions that are then carved out, and could be somewhat of a testing ground to see how some of these technologies work. And yeah, I think just on my earlier point also, I think by no means am I saying that we don't need a data protection law. We do need it. It is high sort of over time, high time that we had one. But just that the way it might impact businesses is not something to completely sort of discount, and build it in a way that there is a truly robust regulator who can work closely with industry on implementation, and I think work with them in also helping them understand often that privacy need not be a blocker as such. For a very small handful of businesses, even now they see privacy as a USP or even a market differentiator, although that's a small number. But just I think that's also a mindset change, that this is the given sort of baseline, and that's how you work around. That's how you develop products to reflect that.
Yeah. So I think we can stop here and take a few questions from the audience. We do like have like few minutes for that. So in the meantime, let me just summarize the broad points that we had covered in this session, we discussed the various kinds of concerns that are emanating from emerging technology. We discussed how there is a need for looking at emerging technology in a more holistic sense and not just on a privacy or informational privacy and data protection point of view. We also looked at the aggregation of data perspective, which Divij had brought in, regarding how sometimes an individual is not completely in control of how they're like generally a data sets and profiles can be built through larger social profiling of sorts. We also discussed how the regulatory frameworks can be brought in for emerging technology, how these regulatory frameworks can impact businesses. We looked at what steps can be taken for enabling ease of access to these regulatory frameworks for businesses, etc. All in all, I think this has been a very, very wonderful chat. I'd just like to check if there are any questions by the audience, because we are sort of
I
running.
think we are, I honestly don't think we have, like, we're just 2-3 minutes shy of the closing time. So
all right.
perhaps we can just close. I'm sorry
Sure.
about that.
So, okay, all right. So I think I'd like to thank the panelists. This has been a very, very fruitful conversation, and we genuinely enjoyed discussing these points with you. There's a lot of points here to take home for all of the people who attended this panel. I'd like to thank all the people who have attended the panel, because I think this has made this event great success for all of us. Please be on the lookout for further working papers that we will be releasing over the next 4-5 months, where we will be looking at several major concepts that have been put forward in the PDP bill. And we will be having events like this, and we'll see you there in the future as well. Thank you, everyone.
Thank you so much.
Thank you. Good night.